Good evening, everybody, and welcome to another edition of my weekly presentation called Legalese, where I like to discuss important topics that relate to motor vehicle accidents and injuries and pretty much what I do for a living. And also to help the consumer and make good decisions about purchasing insurance, making sure they have the proper coverages and things that are going to benefit them and their families and their loved ones. Once again, I'm attorney Chris DeBarry. Welcome to my presentation. If you like what you hear, please feel free to hit the like button. Also, if you could share and comment below, that's greatly appreciated. I often do segments of shows entirely based upon questions and comments. I know I repeat that, but it's true. And I like to get your input. It's very, very helpful to me. So welcome to the broadcast. And the thing we're going to talk about this evening is something that is very, very important. It's going to be very near and dear to the hearts of all Florida drivers. And that is currently what is going on in the legislature concerning Florida no fault. Now, as you probably know, because you've tuned into my show in the past, Florida no fault is the system of reimbursement for your medical bills when you've been involved in a motor vehicle accident. Everyone has to have on their own insurance policy $10,000 of benefits, which will pay 80% of your medical bills and 60% of your lost wages if you've been involved in a motor vehicle accident. And it doesn't matter who's at fault. That's why it's called no fault. And personal injury protection is the name of the coverage, or PIP, as it's sometimes called. However, a proposal to do away with the state's longstanding no fault auto insurance system is currently being considered in the legislature. A bill was filed by the Senate Finance Committee in the Florida Senate on the 15th of January of 2021. This is Senate Bill 54. And if it's passed, what it would do would be to repeal the current model of no fault benefits in the state. And we would go away from that model and we would be involved in a mandatory bodily injury model. So what would happen would be that PIP benefits would no longer be available in the form that they are now required under Florida statutes. And we would then move to a system where bodily injury liability became mandatory. Now, that's the coverage that people are not required to carry right now. It's a useful coverage, and I'll get into that in a little bit. But the PIP coverage, once again, it pays 80% of your medical bills and 60% of your lost wages, or the aggregate of the two, up to $10,000 minus whatever deductible that you might have. And that's how no fault works. And some people are like, well, I have to use my insurance. Well, that's the way the law is written. And it's required that the insurance companies provide these benefits so that consumers can get quick reimbursement for their medical bills, because its public policy basically favors people being able to have access to medical treatment quickly after an accident. And if you had to rely upon another driver's or an AtFault driver's insurance company to admit liability and offer to pay your medical bills, you may be waiting a very long time. And in that case, the injured parties would have to treat with their physicians under agreements called letters of protection, which is a form of credit, which is extended. However, PIP does away with that, at least to a certain extent, in those cases where medical bills don't exceed the aggregate of PIP benefits. So essentially, the $10,000 benefit, and of course that's been fiddled with over the years. In 2012, the PIP statute was overhauled, and the $10,000 was knocked down to $2,500 unless you can demonstrate you have an emergency medical condition, yada, yada, yada. We've talked about that before, and I will do more presentations on that in the future, probably, if it's necessary, but depending on what the legislature does. So in addition to the $10,000, no fault also extends a $5,000 death benefit to insureds who lose their lives as a result of an accident involving a motor vehicle. And the definition of an accident involving a motor vehicle is pretty broad. So you don't even have to be driving the motor vehicle. You could be in the car and the car is turned off and somebody hits you, or the vehicle rolls over you if you're behind your vehicle, like that poor actor died that way. That involves a motor vehicle, and that even though the car is not mechanically operating, it's still going to qualify for a death benefit under PIP, at least in Florida. So here's what the proposed law would replace the PIP model or the no-fault model with. It would replace it with a system of mandatory bodily injury liability. Now, you remember from my past presentations that bodily injury liability is the kind of insurance you hope a driver that causes an accident and injures you is carrying. Because if they are, then you have an additional source of reimbursement for your medical bills, for your pain and suffering, your loss of enjoyment of life, your mental anguish, and all of those other things, as long as you can demonstrate a permanent injury. So that is what bodily injury liability is. It's an additional source of recovery that responsible drivers carry on their policy. And then there's also uninsured motorist, which is something that we should all have on our policies in the event other drivers don't have bodily injury liability or don't have adequate amounts to meet our needs in case they injure us. However, if bodily injury liability is made mandatory, then that will all change. So, and if that does happen, and this is what it'll change to. The proposed law indicates that bodily injury liability would be instituted in the amount of $25,000 per person per crash for an injured person or a person who loses their life, and $50,000 for the bodily injury or death of a person or persons, two or more, no matter how many. $50,000 becomes the limit. So basically, we call that 25-50, 25,000, 50,000, 25,000 per person, but no more than 50,000, no matter how many people are relying upon that bodily injury liability provision of that policy. So now, interestingly, the new bill retains the $10,000 property damage mandatory requirement that we have under the law right now. I don't know what it is about $10,000 that makes the legislature like it so much. It really isn't all that much, particularly when you consider the cost of cars nowadays. They're ridiculously high, and $10,000 barely scratches the surface. It seems to only take into consideration the possibility that accidents are going to fall under that amount. And I've so often been the case that I've had clients that have had expensive cars damaged by people that only have $10,000. They wind up having to go through their own collision coverage. Which, of course, if you have a nice car, you want to have collision on it. But $10,000 really doesn't seem to do enough. And it's an easy thing to change, but they won't change it, and obviously must relate to what they're going to consider is going to be a cost hike for the consumer. And there are some other changes that are made with regard to this new proposed Senate Bill 54. It changes garage liability and commercial motor vehicle insurance. Increases cash amounts for deposits for self-insureds, and establishing financial responsibility for operators of motor vehicles and for hire vehicles that are a little different than what we have now. But that's a little beyond the scope of our discussion for today. But here is one very important point. Repealing the no-fault law eliminates the limitations on recovering pain and suffering from PIP insureds, which currently requires that a person suffer a permanent injury within a reasonable degree of medical probability. So back in the day when they passed the PIP bill, it was a trade-off. Essentially, you can have PIP cover your medical bills at $10,000 of PIP to cover your medical bills at 80%, your wage loss at 60%, and in exchange for you having this benefit exist under your own policy for the speedy reimbursement of your medicals, you have to give up the right to pursue non-economic damages that result from an accident unless you can demonstrate you are suffering from a permanent injury from the accident, and that determination has to be made by a medical provider by the standard, by a reasonable degree of medical probability. So a doctor has to make that determination under the current system for you to be able to pursue non-economic damages, not economic, not your past wages and future loss of earning, not your past medical bills and projected future medical bills. Those are all economic damages. We call them economic damages because an economist can put a dollar value, a present day dollar value on those damages, and make sure that you have in present day dollars what you will need now and in the future to take care of your future needs. So those are economics. You can pursue those damages no matter what under the current system. Non-economic damages, the pain and suffering, the loss of enjoyment of life, mental anguish, and so forth, can only currently be pursued if you can demonstrate that permanent injury. However, if they repeal the no-fault law, then the permanency requirement should go with it. And then people would be able to pursue non-economic damages, whether or not they can demonstrate permanency by that medical standard. Now, there's another provision that's going to be included, and that is a MedPay provision. So we all know, because you've watched my shows in the past, that medical payment coverage is an additional coverage that you can purchase under your policy to supplement your no-fault benefits. So you have your $10,000 in PIP, and you can purchase $5,000 or $10,000, however much medical payment coverage that your insurance company will allow you to pay for. The only difference being PIP or no fault, you don't have to pay that back. There's no right of subrogation that your insurance company would have to pursue that money. They can't subrogate PIP against you. But medical payment coverage, which is contractual, there often is a right of subrogation, or a right that the insurance company has to pursue any of those benefits paid if you receive a settlement from, or a judgment after a verdict against a third party. So under the new provision, the coverage would extend about $5,000 or $10,000 of medical expenses coverage, and also have a deductible of something like $500. Basically, under the new provision, insurers would be required to reserve $5,000 of MedPay benefits for 30 days to cover physicians and dentists providing emergency services or hospital inpatient care. So this MedPay coverage is really designed to address a medical emergency. So the hospitals, the people that have to do the emergency services, medical service for the patient, could be a hospital, could be an ER, it could be a dentist if there's something that needs to be done that's emergent with regard to dentistry. So that's really what the purpose of the $5,000 is for. It's not to reimburse under the way it does under the current scheme. It's really just there to make sure that there's money to pay for emergency medical services when they're needed. Of course, they're going to replace this system of no-fault benefits with a MedPay provision. It kind of begs the question, what are the motives really? There was something said by Senator Dan Burgess. He's quoted, he's one of the proponents of the Senate bill currently in the legislature, basically quotes saying, replacing our no-fault system with bodily injury liability system more appropriately places liability where it should be, with the third party that caused the accident. And while that is true to a certain extent, the purpose of no-fault benefits is exactly not to assign fault, but rather to make sure that people receive the treatment that they need right away, no matter who's at fault. So an at-fault system is just the complete opposite of that. And it would obviously come with its disadvantages. Unless that MedPay provision really, really comes through, people are not going to be encouraged to seek treatment as a possible option. So the mandatory bodily injury has its advantages in that every case will have value to an injured person, but there are going to be drawbacks too if you take the PIP away. Additionally, and this is quoted from Senator Burgess, additionally, the bill creates a new framework for handling bad faith litigation that provides a clear set of standards to govern the conduct of both parties in the claims handling process, which we believe will lead to better outcomes both for insureds, Floridians, and their insurance companies. Now, that is sort of the poison pill to a bill like this, because the insurance industry would like to use the opportunity to create not just the reform of the no-fault system, but they want to create sweeping insurance reform that benefits them, essentially, and to alter or adapt the bad faith rules, which are the rules that exist to keep the insurance companies in line and make sure that they act in the best interest of their insured and not in their own self-interest, would then be altered, and not for a reason that would benefit the consumers. And just to simplify it, and just to create a clear set of rules, isn't a good enough reason, at least in my opinion. The no-fault laws exist the way they do. Insurance companies are held to the standards that they're held to for a reason, and that is that they simply really can't be trusted when it comes to doing the right thing when they have their corporate interest in mind, and often over the interests of injured parties. In fact, the old saying is that the duty to defend a claim is always broader than the duty to indemnify, which means that they've got to try not to pay a claim if they can. If their investigation, there are certain things that they can do to avoid paying. They have to do those things, provided hopefully they're ethical. But the bad faith laws are there to keep it in line. However, the bill right now introduces reform. I'm not going to get into detail about it, but that's kind of the idea. Now, should this really be done? I mean, the idea that they want to repeal the no-fault laws to provide mandatory BI is often touted. Actually, repealing no-fault itself is often expressed as a way of saving the consumer money. However, if many consumers understood what they'd be losing, they would probably think twice about it. According to one study, Florida has the third highest average auto premiums in the United States, with an average of something of like $2,230 based on data from 2020. So now, while the goal of the bill is to reduce insurance premiums, some research indicates that fiddling with the PIP requirements doesn't historically always result in the desired outcome, at least not for a very long period of time. Once again, we're dealing with insurance companies that need very little reason or allowance to raise your rates because insurance is mandatory. They can kind of have their way. When repealing and replacing PIP has been addressed during the last several legislative sessions, and a lot of different permutations have been introduced of the PIP bill. However, none of them have passed. I guess the last one was the closest to passing. However, one of the senators changed his mind at the last minute, and it did not change. Now, back in 2012, when Governor Scott came along, and the PIP bill was altered drastically, and created a lot of changes in basically disenfranchised massage therapists and the acupuncture specialists, and limited the extent to which chiropractors could diagnose an emergency medical condition. While apparently the premiums did drop, it wasn't long before they came back up again a couple of years later, and even higher than they were before. So the profit motive, or should the money saving motive, is really maybe one that's dubious, because it really doesn't seem to play out. Now, further, in 2016, a report by the Florida Office of Insurance Regulation estimated that you'd see a 5.6 decline in auto premiums by switching to a bodily injury coverage requirement. However, the studies conducted 2 years later revealed that repealing the no-fault system would lead to an average increase in premiums of slightly more than 5%. And the philosophy being, behind that the need for Florida drivers to purchase uninsured or underinsured motorist coverage would make up for the loss of PIF coverage, and would mitigate any savings from the regulation, according to one consulting firm. So they're saying, what you're going to save in no fault not existing anymore, you're going to have to make up for in purchasing uninsured motorist coverage. And of course, under the proposed system, you would have the bodily injury liability, so the need for uninsured motorist coverage would be less. It would then become a need for underinsured motorist coverage, which is more or less the same thing. And if this system passes, a $25,000, $50,000 mandatory bodily injury liability requirement is a good start as far as mandatory bodily injury. It's a mixed bag as far as taking PIP away. In addition to litigating bodily injury cases, I litigate PIP cases. So I see a benefit of having PIP stay around, but I see a benefit too in reforming the system to be a bodily injury system. So we will see what this legislature does in some pretty short order. But in the meantime, I just want to say thanks to the people up in Tallahassee that are fighting the fight for us. Dale Swope, in particular, has been up there, and he has always been a fighter for the interests of the insureds and the consumer, both in terms of being a champion of bad faith and very much a champion of the new bill to institute mandatory BI. But that's it for today, folks. If you have any questions, please send them to me. If you like what you heard today, hit the like button. Feel free to share and comment below. Your comments are always welcome. Sorry this didn't deal in great detail with the subject. I just kind of wanted to get a primer out to you. A little bit of a long-winded one, but there nonetheless. But thank you again for tuning in. And folks, have a great week, and we'll see you next week.